Hi there, I'm Bridget Mackay from the law offices of Bridget Mackay. We're an estate planning and elder law firm in Petaluma, California. And I want to talk a little bit about the most recent elections, not about the presidential election, but the propositions that passed in California. One of those propositions was Proposition 19. I think all of you, or most of you who are homeowners, are familiar with Proposition 13 that was passed way back in the 70s, which allowed a more reasonable increase in our property taxes over the years as homeowners. However, Prop 19 has changed some things about Prop 13, most importantly being, for estate planning purposes, the transfer from parent to child exemption. So some of you may not have known this, but if you died or gifted or your children inherited your home in any way, whether during life or at your death, they would receive your residence at the value, the market value that it was at the date of your death. And they would also be able to pay the same amount in property taxes that you have been paying. So that transaction would not have elicited a reassessment of the property from a property tax standpoint. So that was a real gift for many families to be able to transfer homes. In addition to that, you could have transferred, each spouse, if you were a married couple, could have transferred in addition another $1 million in real property at the assessed value to children and take advantage of that exemption as well. That has all changed with Prop 19. Prop 19 will start in 2021, February 16, 2021. This new rule will begin to be enforced in California for transfers of property between parent and children. This exemption also applies to transfers between grandparents and grandchildren as long as that parent generation is deceased. So the change is you can still transfer from parent to child, maintain the property taxes that the parent or grandparent in other cases was paying. However, the recipient needs to use that residence as their primary residence. In addition, the extra $1 million in real property for each parent to transfer to a child has been eliminated. So our options as planners have gotten really reduced. So before you panic, I want to, because many people are wanting to transfer their homes to their children now to take care of and take advantage of the parent-child exemption. I want to caution all of you from doing anything hastily. You should talk to your estate planning attorney before taking any sort of action, because there are other consequences to doing that besides the tax consequences, and those repercussions could be severe. So just wanted to make you aware, we just learned that this proposition passed. There are plenty of other changes in that proposition as well as it relates to property taxes, but this was specifically important for estate planners and folks who have trusts or who are planning to have their residence being passed on to their children or their grandchildren. So again, contact a professional before you make any moves along this line.